Hi guys! Welcome to another episode of Atty. Vlogger, Law for the Everyday Layman. Today we have part 4 of contracts, okay? And we'll begin with the defective contracts, specifically rescissible contracts, okay? So if you like my videos and you want to see more, please hit the subscribe button. Please remember that this is only for educational or informative purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? So what are rescissible contracts? These contracts are valid. Okay? They're valid because all the essential elements for validity are present, namely consent, object, and cause. Okay? So they're valid, but they are defective due to lesion, L-E-S-I-O-N, or what is known as economic damage, or the fact that the price is unjust or inadequate. Okay, so what is rescission? In general, rescission is a remedy allowed by law for the reparation of damage caused by a contract through the restoration of things to the condition prior to the execution of the contract. Okay? Now, please don't be confused because you have rescission under this topic, no? Under 1381 of the Civil Code. But we also have rescission of obligations under 1191 of the same code. So, where's the difference, no? First, in 1381, on the rescissible contracts, the topic of today, who may bring the action? It's the injured party or a third person who has suffered lesion or fraud. Okay? In 1191, the only party who can bring the action is the injured party in a reciprocal obligation. In 1381, there are several grounds listed under the law, okay, as to serve as basis for rescission. But 1191 has only one ground, and that is substantial breach. Okay? In 1381, the courts cannot extend the period for performance, but in 1191, there may be extension of the period of performance by the court. Okay? Finally, in 1381, it can cover any kind of contract, whether unilateral or reciprocal. Okay? But 1191 only applies to reciprocal obligations. Okay? So, rescission here under 1381 on rescissible contracts is a subsidiary action, meaning the injured party cannot claim rescission at the first instance, no? He must resort to his other available remedies before he may invoke rescission, okay? So, in other words, the injured party must have no other means by which to obtain a reparation because rescission under 1381 is a subsidiary action. Now, what is the extent by which rescission may be claimed? Okay? Rescission may be claimed only to the extent necessary to cover the damage suffered by the injured party. In other words, the whole contract does not have to be rescinded, okay? Again, only to the extent by which the injured party has suffered damage, okay? Now, as to the effect of or consequence of rescission, it is the same for 1381 and 1191, okay? It is the duty of mutual restitution. In other words, each party must return whatever they may have received by virtue of the contract. In other words, a party must return the object and its fruits in case he has received them, and the other party must return the price and its interests in case he has received it. Now, rescission and mutual restitution will not apply in the following cases. Okay? First, if the one who is demanding rescission cannot return what he has received. Okay? Second, there will also be no rescission if the object of the contract is now legally in the possession of a third party in good faith. Okay? It is legally in possession of a third party. Take note, in good faith. Okay? Why? Because if a third party is in bad faith and he knew of the defect of the contract, then he will be liable to return the object. And the law says, in case it is impossible for the third person to return the object, he shall be liable for the value of the thing and damages if warranted. Okay? Now, these two instances I mentioned where rescission does not apply, again, where the one who is demanding rescission cannot return the thing, and when the object is in the possession of a third person in good faith. Okay? In those two cases, since rescission is not available, the remedy is now one for damages. Okay? It's now an action to claim damages. Okay? Now we can go to the kinds of rescissible contracts. Okay? First, we have contracts entered into by guardians in representation of their wards. Okay? Whereby the ward suffers lesion in the value of more than 1/4 of the value of the object or the property of the ward. Okay? To help you understand what is required, first, take note, the lesion must be more than 1/4 the value of the thing. Okay? So, for instance, the property of the ward, subject of the contract, is valued at 20,000 pesos. Okay? And 1/4 of the value of 20,000 is 5,000. Okay? Now, what if the guardian sells the property of the ward at 15,000 pesos? May the contract be rescinded? No. Okay? Because there has been no damage that exceeds 1/4 of the value of the property. It does not exceed 5,000. What if the guardian sold the property at 16,000? Can the contract be rescinded? No. Okay? Why? Because the damage is not more than 1/4. It does not exceed 5,000. The damage is only 4,000. Okay? And now, what if the guardian sells the property at 14,000? Then yes, this time, the contract may be rescinded because what is the amount by which the ward is prejudiced? It is now 6,000 pesos. Remember, the guardian sold it at 14. Okay? And the actual value is 20. Okay? So, the ward suffers lesion in the amount of 6,000 pesos, which is more than the 5,000 pesos, which is 1/4 the value of the property, which is 20,000 pesos. Okay? So I hope that clears that up. Second kind of contract, rescissible contract, is a contract entered into in representation of absentees, whereby the absentee suffers lesion in more than 1/4 of the value of the property. Okay? Same explanation as earlier, and the period within which to ask for rescission, whether it be in case of guardians on behalf of their wards or representation of absentees, is 4 years from the termination of the guardianship in case of guardians, or 4 years from the time that the domicile of the absentee is known. Okay? Now, take note that the rescission will not apply to contracts entered into in the cases that I talked about, which have been approved by the court. Okay? So, of course, it won't be rescinded because the court has already checked if there has been a lesion, no? And if the contracts have court approval, then they cannot be rescinded anymore. Okay? Let's go to the third rescissible contract, no? Contracts entered into in fraud of creditors, when the creditors cannot in any other manner collect the claims that are due them. Okay? So what are the requisites? First, there must be a credit prior to the contract that is being rescinded. In other words, let's say X now enters into a contract with Y, but X previously had a debt owing to A. A now has a credit prior to this new contract between X and Y. Okay? So the credit that this circumstance is talking about must have existed before this contract which is being sought to be rescinded. Okay? Second requisite, no? There must be a fraud or at least intent to prejudice the creditor. Okay? Third, no? the creditor, the creditor with the previous credit, the creditor must have no other legal remedies or other means by which to claim the debt which is owing to him. Okay? And fourth, the object is not in the possession of a third party who is in good faith. Okay? So now the law gives us certain presumptions to make our lives easier. Okay? So what if the contract that is entered into to defraud a creditor is a gratuitous contract, no, like a donation, like because it is the cause is the pure liberality or beneficence of the donor, no? The law says that if the donor did not reserve sufficient property to answer for all his debts prior to the donation, then the donation is presumed to be fraudulent. Okay? That's the rule when it comes to gratuitous contracts. Of course, no, kasi if the donor has previous debts, he should first answer them all, okay, and satisfy them all before he enters into that contract of donation where he gives away his property. Or at the very least, he must have reserved sufficient property in order to answer for these debts, those prior debts, no? And when he does make a donation, let's say of all or nearly all his property, then there is evidence of intent to evade the satisfaction of the previous debts. Okay? Now, let's go to the next presumption. In case of an onerous contract, it will be presumed to be fraudulent in case there is already a judgment over the thing that has been alienated or the thing has been previously attached by judicial process. Okay? Because the person who is alienating the thing or transferring the thing already knows that he stands to lose it because of the judgment or the order of attachment. So he now alienates it and he is presumed to have entered into that contract fraudulently, okay, or to defraud his previous creditors. The law also gives us some badges of fraud, no, for us to identify if fraudulent acts have been committed in order for a contract to be rescinded, no. I'll give you some examples. First, where the cause or consideration is fictitious or unusually inadequate, okay. Second, if a person makes a transfer over a thing belonging to him while the suit over the thing is pending. Okay, there's a pending case over that thing. Third, sale on credit by an insolvent. No? If you are an insolvent person, you will necessarily want to receive payment for the thing you have sold in order for you to satisfy your obligations. In case you sell it on credit, you are not getting paid right away. Okay? So the presumption there is that you entered into that sale on credit to defraud your other creditors. Okay? Another badge of fraud is evidence of large indebtedness or of insolvency. Okay? Another badge of fraud is the transfer of all or nearly all of the properties. Okay? And one more, I'll give one more. The failure of the buyer, no? The buyer to take possession of the property. Okay? Because it's highly fishy. You know? It's highly doubtful. Because buyer would usually at the very least, no? Will usually want to take possession of the thing that he buys. Okay? So these badges of fraud, no? While they may not be strong individually, but when taken together, then they will be very good evidence of fraud. Okay? Let's go now to the fourth kind of rescissible contracts, no? In case a contract is entered into over a thing that is subject of a pending litigation or a pending case, then that contract may likewise be rescinded in case the transfer was made without the knowledge of the litigants, the parties to the case, or of competent judicial authority, meaning the judge, or the court. Okay? Why? Because the party who is transferring the property subject of the litigation knows that he stands to be deprived of his right over that thing. And when he does that, there is likewise intent to commit fraud or evade the satisfaction of the judgment in case it is unfavorable to him. Okay? Next, the fifth kind of rescissible contract under 1381 are payments made in a state of insolvency for debts which are either not yet due or cannot be due at all. Okay? The person here is already insolvent. No? His liabilities already exceed his assets. And then he goes and pays a debt which is not yet even due. The common sense dictates that if you have several debts, you pay first the ones that are already due and demandable before paying something that is not yet due. Okay? Or, in case of debts which cannot be due at all, like natural obligations, or in case an obligation is already prescribed. Okay? A person may want to fulfill those, but they are not immediate in nature, no? A party must first fulfill his civil obligations rather than his natural obligations or those which have already prescribed. Okay? So, the last ground, according to the law, is all other contracts specially declared by law to be subject of rescission. I'll give you a few examples. In the law on succession, okay, a partition, whether judicial or extrajudicial, may be rescinded on the ground of lesion. Okay? Where in which case, where the co-heirs who stand to receive inheritance from the decedent or the person who died, one of those co-heirs receives a thing, okay, whose value is less than at least 1/4 of the share to which he is entitled. Okay? And the contract on lease, in case of violation of the obligations of the lessor or violation of the obligations of the lessee or the lessor respectively may bring an action to rescind the contract. Contract of sales, okay? In case of a sale of real property, a buyer may ask for rescission in case the lack of area in the real property sold is not less than 1/10 of the area stated in the agreement, or in case of a movable thing where the inferior value of the thing, okay, exceeds 1/10 of the price agreed upon. Okay? So that's it for the rescissible contracts, and I hope you may have picked up a thing or two. Please tune in again to watch my next episode on voidable contracts. Okay? See you soon. Bye.